Welcome to the Center Collaborative, Creative Solutions in Behavioral Health and Criminal Justice, brought to you by the Oregon Center on Behavioral Health and Justice Integration, which is also known as the Center. We at the Center are all about solutions. Our job in Oregon is to facilitate improvement of the system so behavioral health and criminal justice can work better together to engage people in treatment while promoting public safety. I am your host, Chris Thomas. I hold a master's degree in clinical psychology and have focused on the intersection between behavioral health and criminal justice for 20 years. Over 7 of those years were behind the walls of a maximum security prison. During this podcast, you will have the opportunity to sit in on real, in-depth conversations with experts about complex topics in a way that is both fascinating and digestible. We will focus not just on what is wrong with the system, but what is going right and how we can work together to evolve. Today's episode is part 2 of a 2-part series with Terry Schroeder, Oregon Health Authority Civil Commitment Coordinator within the Certification, Licensure, and Technical Assistance Department. During this episode, we continue to discuss the process for civil commitment. We talk about the examiner and what they do within the process. We also talk about the difference in the bar for initial commitment versus if there is expanded criteria. We discuss the nuance around if someone is willing and able to participate voluntarily in treatment. We also talk about a bar for assisted outpatient treatment, AOT. Finally, we talk about the importance of families continuing to reach out for help. I learned a lot during my conversation with Terry. I think you will too. Welcome to our conversation. Moving back into the process, I'm glad we took the time to talk about self-care and wellness and vicarious trauma. I also want to circle back to talking about the process. So you have the investigator who comes in agreement with the doctor that civil commitment is something that should be looked at. And then there is yet another step with the examiner before you get to the court process. So with the examiner, what kind of credentials are we looking at for examiners? What do they prepare for the court process?
Great question. And they are very different roles. The investigator is representing the state. And once the investigator has made a conclusion of recommending to the state that they go forward with a civil investigation, that representation happens through either the district attorney's office or through the county counsel's office that has representation. At the same time, once that decision is made, the individual is being referred to a public defender typically who represents the individual's wishes of not being civilly committed. And so you have these two sides, the state and the public defender, promoting a particular outcome, which is either commitment or not commitment. The investigator creates what's called an investigative report, and that's what stimulates all of this. They create this report with a recommendation, going to court, not going to court, and that goes to the court that is going to provide the court hearing. The court hearing then appoints an examiner to examine that individual, and they have a different role than the investigator. They are an advisor to the court. They are not to have an agenda as to what the outcome should be, but they should be providing the judge with the best possible opinion as to whether or not the clear and convincing bar has been achieved at the conclusion. And so their job is to be an independent counsel to the judge and to provide them with information and expertise. And for that reason, they have an ability in the courtroom to provide an opinion as to diagnosis, which the investigator does not have that authority to provide in the courtroom. They can make a recommendation in their investigative report as to what they believe the physician's going to say as to diagnosis, but they themselves don't get authority as an expert. The examiner does. So the examiner will advise the court as to what the diagnosis is, and they'll also advise the court as to whether or not the state has met the bar of clear and convincing evidence for a civil commitment, and also make recommendations to the court as to what kind of setting the person would be best served at following a commitment hearing, if that's what the judge decides. They can also cross-examine witnesses, whereas the investigator cannot. So the investigator essentially launches the civil commitment hearing process The examiner plays a much more active role in the hearing itself in terms of gathering information, clarifying diagnosis, clarifying risk factors, and most importantly, clarifying the connecting points between the mental illness and the risk. That's the thing the judge needs to know more than anything else is how does this mental disorder create risk and how are there no mitigating or less restrictive alternatives to keeping this person safe. So that's what the examiner provides in essence. I've been an examiner for many years here in Oregon, and this is a unique role. I've done civil commitment work in Washington and Montana as well as Oregon, and the examiner role doesn't exist in either of those two states. It exists here in Oregon, but not in Washington, not in Montana. That's the other thing is you see civil commitment work done differently in different states throughout the nation with different emphasis and different populations included. In Oregon, we tend to exclude folks with primary substance abuse disorders from civil commitments, whereas in other states that is allowed. Each state has its own kind of emphasis in terms of the population. The other thing the examiner does is advises the court as to whether or not the person has what's called expanded criteria. That is where there's a foundation established that this person has a prior mental health history and that mental health history has caused this person to be placed twice within the previous 3 years. So the legislature has allowed for the time frame to be 3-year period prior to this current commitment period to be looked at in terms of whether or not there's an established mental disorder and if that person's symptoms and behavior came up as a result of their mental disorder, causing them to be civilly committed. When we talk about placements, we're talking about either civil commitments or a person who's been civilly committed and then recommitted during that period of time, which is called recertification, or if a person has been under a civil commitment, discharged from an acute care setting on a trial visit, which is like a probationary period into the community, but for any number of reasons aren't able to adhere to those conditions, they then have to be revoked through a court hearing back into the acute care setting. That would also be considered a placement. So any one of those 3 types of placements, 2 civil commitments within 3 years, civil commitment and recertification within 3 years, or a civil commitment and revocation, all which require court hearings or a court approval to occur, going back to a more restrictive setting. All of those 3 things, if they occur within a 3-year period of time, and any one of those placements looks similar to what's happening now in terms of pattern of behavior, then that can be applied to a expanded criteria, which means the court does not have to look at this person's current situation with quite the high bar of clear and convincing. They can say, I can see that this is already beginning to roll downhill, but we don't have to be so far into it that this person is an acute risk to hurting themselves or others. So that's the foundation that you have to establish, and the examiner is critical in advising the court as to whether or not that foundation is there.
I see. So it sounds like for initial civil commitment, where the extended criteria isn't a piece of it, the bar for a civil commitment is a higher level than if these other things had occurred where you can have the extended criteria, the bar isn't as high as it would be for an initial commitment. Am I hearing that right?
That's exactly right, Chris. And
Okay.
the other added thing to that is that the legislature indicated that the examiner has to advise the judge as to whether or not the mental disorder is of a serious and persistent nature. What they're talking about there is somebody who has a significant mental disorder such as schizophrenia, schizoaffective disorder, manic depressive with psychotic features, things of that nature where the symptoms are serious and the functional limitations are significant and they persist over a longer period of time. They go on further to say that a disqualifying diagnosis would be substance abuse disorders and some personality disorders, primarily antisocial, sociopathic personality disorders that are more likely to be found in a criminal justice setting as opposed to a mental health setting. It gives you a good idea of what the legislature intended in terms of who these civil commitment processes are intended for. And these are people who have significant mental health disorders that result in significant functional impairments that occur over a significant period of time, which is why the commitments are 6 months long, 180 days. And that's who benefits the most from these kinds of interventions of civil commitment. The legislature has decided not to define what a mental disorder was initially as you look at the statute. A mentally ill person, as they call them, are people with a mental disorder who is a danger to self or danger to others, but they don't define what a mental disorder is initially for that initial piece. But when you look at the expanded criteria, they're much more specific, which gives you an idea of who they're pointing this towards, but they kept the door wide open to begin with to consider any number of different mental disorders that may cause the person to be considered. But this is why you see so many people ruled out of the system, because they're not really meeting that serious and persistent mental disorder.
Oh, interesting. I think I'm following you in that statutorily, when you're talking about initial commitment, it sounds like there is a wide range of conditions that would qualify as long as there is the danger to self or others, functional impairment. It sounds like there's a wider range of options as far as what the condition might be that's driving that versus when you're looking at the extended criteria, it's a much smaller group of diagnoses that would qualify for that extended criteria.
Yeah, so if you imagine a big filtering process diagnostically, initially it's a very wide open thing because there's so much that could be potentially qualifying situation or diagnosis. But as you get farther and farther into the process of actually recommending the civil commitment, you find yourself most of the time recommending for civil commitment people who meet that type of serious and persistent mental disorder. And the reasons for that are manyfold. For the majority of the cases that are initially being placed in custody, taken to the hospital, or placed on a hold for an investigation, folks who have other diagnostic issues, they are more temporary, they're more transitory, they respond better to certain kinds of interventions, and the risk factors immediately are reduced, which is why these folks end up being discharged out into the community after a short period of time at the dismay of family members and other folks. Because there's also an awareness that it's very likely that they may cycle back into that crisis state again. That doesn't mean the problem's gone away. It just means that it's not a persistent one that lasts such that it requires a civil commitment or is allowed through the requirements of civil commitment. Those folks end up being discharged with referrals, and hopefully they follow through, but oftentimes that isn't the case, or it's the living environment isn't stable enough for them to maintain the gains that they made while they were inpatient. And so they slide back into those other patterns of decompensation or behavior that result in further crisis. But it is those folks who have the serious and persistent mental illnesses that cannot be discharged into those settings safely. And so those are the folks who are maintained in the hospital and then move on forward to a civil commitment. The examiner is the one who advises the judge as to whether or not that, in fact, is who is in the courtroom at that time.
That sounds like an incredibly complex job that has a lot of different aspects to it. I'm curious, are the credentials different for being an examiner versus an investigator?
Yeah, and they are. Because the individual is making those kinds of determinations and also able to cross-examine witnesses and that sort of thing, they are expected to have at least 3 years of experience working with folks with serious and persistent mental illness. And so they have the diagnostic skills to be able to advise the judge around that issue. They are supposed to have master's degrees in psychology or counseling, just as the investigators are, and they are supposed to take my class. But one of the differences between the two is that once you become an investigator, you take my class initially for that initial certification. You're not required to take my class 3 years later, which both of these certifications are for 3 years, and then they get recertified. The investigators can get education and training in any number of different fields that may be qualifying education towards that recertification of their investigator status, but the examiners have to take my class every 3 years in order to be updated in terms of case law, statutory changes, anything that helps them to be able to advise a judge accurately about certain aspects of the case. And so they have to take that class every 3 years. They have to have 3 years of experience providing that kind of training, and they have to have recommendations from other examiners who are familiar with their work to say that they have the qualities and experience to be able to provide that role, in addition to having a director's recommendation too. So it's a more extensive requirement process for the examiners. And so they tend to be more seasoned clinicians and comfortable with that courtroom setting process.
I'm curious about, and this is an ongoing conversation in this intersection between behavioral health and criminal justice, is what happens when civil commitment, let's say, doesn't get all the way through the process, through the different layers of civil commitment, or ends up going to the hearing and civil commitment does not occur. What happens in that circumstance? Are there safety nets that happened? Are people put into other programs? Is it all completely voluntary? What
Good
happens?
question. Again, one of the decision points that are made, and something the examiner advises the judge about, is whether or not the individual is capable of being treated on a voluntary basis. Again, even for the court hearing, you're looking for less restrictive alternatives to the civil commitment. So one of the questions is, can this person be voluntary? And so that's a clinical question in regards to that person's ability to understand that they have a mental illness, what their insight is to that, and whether or not their mental illness is not so compelling that they can follow through with an agreement to be in the hospital. Because one of the things you'll see with folks with psychotic disorders, et cetera, is that they're very compelling for the individual. Sometimes you'll even see somebody who says, I understand I have a mental disorder, and I also understand that if I am being told by these voices who I perceive to be of a higher authority, I will follow through with them, even though I know it may not at this moment be in my best interest to do so. And even in those circumstances, a person can't be a voluntary admission. And so what we talk about is a person being able to be in good faith in their voluntariness. So even if they state that they're voluntary, that does not mean they can't be civilly committed. And there's case law that also states a person who is even good faith in their voluntariness but still meets the civil commitment criteria can be committed. So that's one aspect to this whole thing. And that would be an example of that. So the person is saying, I want to be voluntary, but I can't control my behavior. That would be somebody who would still be civilly committed because they don't have control over their behavior at the time. At the court hearing, once the judge makes a determination that the bar has either been met or not met for civil commitment, if the bar hasn't been met, there'll be questions as to what kind of referrals will be made for that individual, but they are, in essence, allowed to be discharged from the hospital at the time that the hearing completes. Whatever arrangements that are being made for that person should be made prior to the hearing in the event that the person's going to be discharged. But essentially, the individual is on their own to make those decisions to follow through or not follow through with any of those recommendations. There's no mandate that they do so. As Judge Wilkie talks about, the AOT and other options are considered and may be advised at that time of the hearing. And so the judge will look at any number of different outcome options in addition to civil commitment that may meet the needs of the individual and the safety for themselves and the community. But ultimately, at the bottom of it all, the individual has a choice to make about what they will or won't do following that. Even if they're in agreement to being a voluntary patient, within a day or two following that, they could decide to discharge and they would not be civilly committed from that point forward, unless there's new information or new risk factors that show up that weren't addressed in the hearing. You can't try a person or have a person under commitment for the same issues twice. You have to have new information.
That's really helpful to know. I'm really glad that you brought up assisted outpatient treatment because there seems to be some confusion in Oregon around assisted outpatient treatment. I've heard folks say that they believe that you have to be at the civil commitment bar for assisted outpatient treatment. And yet I've heard Judge Wilkie talk about, and I just heard you talk about, that if civil commitment does not end up occurring, that assisted outpatient treatment is an option. So I'm wondering if you can talk about that confusion a little bit.
Yeah, the individual does not have to meet civil commitment criteria in order to be sentenced to assisted outpatient treatment. In fact, that is the criteria, in part, is that the person does not meet the civil commitment criteria. Otherwise, they would be civilly committed. Assisted outpatient treatment is for those individuals who obviously show the need for the treatment and also show it's a voluntary agreement per se, in that If the individual doesn't agree to doing this as an outpatient treatment, they're not going to follow through, even if the judge so orders it. And so this is the thing that is looked at oftentimes. Is this individual willing to engage in an AOT process, assisted outpatient treatment, if the judge orders them to do so? Then we have a potential success here. This is called the black robe effect, essentially, where the individual wants to have that kind of engagement with somebody of authority, like a judge, to be overseeing their treatment, and will benefit from that kind of interaction, oversight, and supervision. But if they don't follow through with it, what many clinicians will say is that there's no teeth. In other words, they can't revoke the person like they could on civil commitment from a trial visit. There's no consequences for not complying with the judge's orders, which is why many mental health programs and investigators don't authorize or endorse that type of a recommendation. So it's really a matter of fit in the state of Oregon to find the right person who needs to have that kind of a commitment and requirement by the judge to follow through certain things, benefits from those folks having contact with the judge, but also is not so disabled by their illness that they meet a civil commitment criteria at the same time. And I've seen it work in a number of cases, but I can also see many times where it doesn't make sense to make that recommendation in the state of Oregon, in part because the state of Oregon does not require a certain cachet of services for AOT. In other words, the benefit to the individual receiving those services is not so robust to make it highly attractive to the individual getting those services. To put it another way, the mental health centers are not given the funding and or the authorization to require a certain wraparound type of program for a person under AOT. I think that's absolutely a missing piece to this, in that it has less meaning for the individual on AOT, and therefore they don't follow through as readily, and there's no consequences for them if they don't.
So it sounds like AOT, assisted outpatient treatment, is experiencing what we experience in a lot of the systems in Oregon, in that with the behavioral health system not being funded quite as robustly as required for our population, that it's difficult to have the breadth and depth of services within the community for whichever population we're talking about with behavioral health and whatever program one would be associated with. That sounds like that's something we hear a lot across the system, and that assisted outpatient treatment is another aspect of that, where we need more services, we need more support, we need more breadth and depth of services.
Yeah, in my view, and this is just my view of this over all these years of doing this work, it's the combination of things coming together that makes this process work for the person. And one of them is that the person is fit in the right system. So at that initial juncture point of whether they're moving towards a criminal justice or a mental health system, if that's the right decision or the right fit for that person, if what's driving the issue is of a mental health nature, going into the mental health system is the better direction to go, because it's meeting their needs more effectively, and more importantly, it benefits that individual as opposed to going to a criminal justice system. Once in the mental health system and the referrals are made, it has to be meaningful for that individual, for the person to follow through. Leverage care is only an avenue or a vehicle to getting the person engaged in treatment. The real work is getting the person engaged in treatment that's meaningful, such that it benefits them, and they see that benefit and they want to continue that engagement. To just leverage care without it being meaningful is not effective over the long run. AOT, if it is meaningful for a person and it meets their needs and provides them the support systems that they need in order to begin to move forward as a human being in their world, in their life, and they see the value of it, they're going to continue. Even if they have missteps and relapses, we all make mistakes, we all don't stay disciplined. Those things happen. That's to be expected. But if the system's always there to support them in a way that they feel has value and meaning, then they're going to continue to be engaged. If we only leverage treatment without that piece in place, people will naturally, you and I, won't continue to engage in a system that only requires us to, but we see no value in doing. But that's just human nature.
Absolutely. If treatment occurs and you're not meeting a person where they are and what they need in a way that is meaningful, why would you engage? Why would any of us engage? And it's interesting, there is definitely a change that's occurring in the system that I'm really glad to see over the years. The traditional system of you have treatment, but you engage in treatment in the way that we think that you should engage in treatment. And then the realization that has occurred over the years and the change in the system around meeting folks where they are and realizing that the probability of engaging in treatment and staying with treatment is going to be higher if the treatment is meaningful and meeting someone where they are instead of expecting them to engage the way we think
Right.
that they should engage.
That's the real goal and golden ticket, so to speak, to a person getting better. But I will also say this, the civil commitment statutes and rules are in place to intervene in those circumstances where the overriding factor of risk and safety overrides those concerns for a short period of time. That's when those things happen. A person becomes civilly committed because the risk factors are so significant, either to that person's safety or to somebody else's safety, that for the short term, there's going to be a leveraged, controlled setting in place. But then the work all is about trying to find the right fit for that to be meaningful, for things to really improve from there. So it's like this immediate, let's get containment and control and safety for everybody, and then figure out what the right next steps are going to be within what the law allows for.
Absolutely.
The work of it all. But it does have to be meaningful for it to be effective over time.
I couldn't have said it better myself, that civil commitment definitely needs to be there for when the danger to self or others or someone cannot take care of themselves. At that point, then you're just trying to contain and make sure that person and other people are safe, and then making sure that the treatment that occurs is meaningful for that person, especially later on as they do better, to assure that they continue to engage.
Right.
So in the time we have left, Terry, is there any last thoughts that you would like to share with our listeners, things that you would want them to know?
I think for all of the professionals out there, I want to acknowledge just the challenge and the complexity of the work in the environments that are being done. Is being done, I think, for the most part, to the best of everybody's ability. I think that as long as we continue to try to silo these issues, criminal justice, chemical dependency, and mental illness, into separate systems, we're going to continue to struggle because people really don't fit that way. They are all of those things at times. And if our systems can work more cooperatively and interactively that way, the better it is for the people that we try to serve. I think slowly we're coming to the awareness that these are an integrated thing as opposed to separate things. We're all trying to get to that same place within our systems that are extremely complex and come from different perspectives altogether. Patience for all of us. For all those folks out there who are struggling with mental disorders, we are doing our best to try to be compassionate and to try to be real human beings, and also to make the best decisions that we can for your safety and for the safety of others under difficult circumstances. For family members, continue to work with us, continue to communicate with us about your concerns, about your family members. And even though we may not be able to respond in the way that we would like to, in a more proactive fashion, because that's not how the laws are set up right now, to not be proactive, but to be reactive to circumstances. We're working to try to change that and be more responsive to your needs. It's not that we don't care. It's that we are at times not able to respond the way that we would like to, because we are also protecting that person's rights. And that interplay between those two things is very complex. But keep informing us as to what's happening. Because oftentimes what I see that's most concerning to me is that if a family member or a friend or somebody who's trying to get help for somebody makes a phone call because of a crisis situation and the person's released at the time or a day or two later, becomes very frustrated and feels like the system, quote unquote, isn't working and won't help. Then the next event, which may be slightly different and more dangerous than the one before, there might be a nuanced change in that circumstance that actually rises to the bar where a civil commitment or a custody is appropriate. But the family member may not see it as any different than the time before. Keep calling, keep letting us know what's happening, and as soon as we can help, we will.
I think that's a great final message for the podcast, especially keeping hope and also for families keeping in contact with the people who are trying to help, because there could be something different this time. I'm wondering, could there be a preponderance of things? So is it that a certain bar needs to be met, or is it that there's so much contact that you need to build a case? Does that make a difference for working with an individual?
Yeah, so a number of things you're looking at that way as a director's designee or a crisis worker or an investigator doing the investigation is that you'll look at what are the level of severity of the symptoms and also how frequently are they occurring. What impact, if any, are other less restrictive alternatives that have been applied in the past? And if we've seen something not work in the past, there's no point in believing it's going to work again in the future. You start to rule out less restrictive options that might have been considered in the past but have been tried and not worked. And you find yourself at a loss of any other type of option other than a civil commitment. So again, you end up with, this is what I have left because nothing else is working. Or you can see that the person's behavior is escalating and getting worse each time. And so if you see that pattern as well, so what's the trajectory, what's worked in the past, what hasn't, all of these things come into play, and what triggers it too, and what environment is the person going back out into that triggers another crisis cycle to occur. Or is this a mental disorder that is just on its own got a history of escalating? If you can establish that kind of foundation, that also helps. So any number of different dynamics can result in combination to making a recommendation to civil commitment that is difficult for a family member or a non-professional person who doesn't do this all the time to see. We want to know all sorts of things in terms of how is this happening over time? Is it getting worse? Is it getting better? Is it staying the same? What's the pattern associated with that person's behavior that we can begin to see emerge? And what direction is it taking? I mean, you might start with just verbal aggression or insulting, but then it turns into much more intense verbal aggression, or it turns into posturing, or it turns into throwing things or damaging property. And so you see an escalation of aggression that may not have resulted in somebody being harmed, but you can see it moving in that. Is it focused on one person, or is it focused on a lot of people, or whoever that person comes into contact with? What are the person's internal thought processes, which is incredibly important, but sometimes people don't know what that is in terms of detail. But one of the things the investigators want to know is what is happening internally that is causing the person to basically override what is our natural tendency to not be violent. What is justifying that violence? What's compelling it? There's a number of symptoms that you look for as a clinician to help understand the dynamics of that, but those are things important to know too. So you take all of that into combination, and maybe also is the person exaggerating their symptoms and their circumstances by the use of drugs and alcohol, which is often the case. So they may already have a mental disorder going on that is causing a certain level of risk, but then when you add methamphetamine or some other chemical that inflames it and makes it even much more intense, then the risk factors become much higher. Because that's the case, that doesn't mean the person can't be committed. It just means that if you can associate the drug use with the exacerbation of the mental disorder, and what is the probability of this person using again, if that's very high, then you have a combination that can possibly go to court. These are the kinds of nuances that are sometimes not known to people. As we establish those facts, it is at that point that you can then give a judge the correct information, accurate information of evidence that's admissible, that they then can make the decision. Really what this all comes down to is doing our very best to give the judge the best information that we can for them to make the best decision that they can within what the law allows. And sometimes it takes a while to gather all of that in a way that's effective.
It's an incredibly complex topic and process with lots of myths around it. So I'm so glad you joined me today, Terry, and we were able to talk about the complexity and the nuance and touch on some of the myths and the misconceptions around the civil commitment process. Thank you so much for joining me. This was a great podcast, and I'm just really thankful that you took the time to join me today.
It was a pleasure to talk about something that is near and dear to my heart in terms of the importance of it for all of us.
The Center Collaborative is a production of the Oregon Center on Behavioral Health and Justice Integration, a specialized division of Greater Oregon Behavioral Health Incorporated. It is produced by me, Chris Thomas, with production assistance from Patrick Kennedy. Music by Patrick Mulvihill and Patrick Kennedy. Subscribe to the Center Perspective using your favorite app. To learn more about criminal justice and behavioral health in Oregon, visit the Center's website at ocbhji.org. You can also find us on Facebook. We'd love to hear from you. Please reach out to us. Join us next time as we chat with the experts about programs and partnerships at work within this complex and yet compelling field.